SJC-12504, Commonwealth versus Dennis O. Rosa-Roman.
Mr. Fishman, still good morning. Good morning.
Good morning. May it please the court, Neil Fishman here for Dennis Rosa-Roman. Your Honors, I made a number of arguments in the brief. There are about 6 arguments, also a prayer for 33E relief. But I think it's in the best interest of my client that I focus today on the suppression issue, which is fact-intensive and a legally intricate issue. I'll try to take your Honors through that issue in a temporal fashion. The suppression issue, the motion to suppress was addressed to, first off, to a statement that defendant made in November 5th, I think that's 2013, in Westfield, during the Westfield interrogation, the November 5th interrogation. During the interrogation, he said, "I want to know what's going on. You guys trying to pin this on me? You guys trying to what? What's up? Because I don't have no time here. I got to go." Of course, the statements should be viewed in their context. And the context was as follows. At the time the defendant made the statement, he was viewing a photo of the decedent's bedroom and visibly upset, that you can see on the DVD. According to the detective, Detective Gibbons, he said the defendant seemed upset and agitated. The defendant was concerned the police were trying to pin the crime on him. That's the word he used, pin. And the video shows that he's highly agitated. So the argument I'm pressing here today, that was also pressed, of course, in the motion to suppress, was that under the totality of the circumstances, this was a sufficiently clear and unambiguous invocation of my client's right to invoke his right to silence.
Now, before you go too far, is this now something for us de novo because it's based entirely on the videotape, or is it clearly erroneous because it's based on testimony?
My understanding of the law when it comes to suppression issues, where you have a record before you, as you do in this case, not only of the DVDs, but of a transcript as well, to my knowledge.
Transcript of the interview, you mean?
Of the interviews.
Okay.
That yes, it's de novo review.
So there was no testimony from anybody during the course of the motion to suppress, which mattered in terms of the judge's findings.
The only area, insofar as this comment is concerned, from the motion to suppress, was Detective Gibbons said he seemed agitated.
So Gibbons testified.
He did during the hearing on the motion to suppress. That's also in the record on appeal. Of course, the cases that support suppression here are Smith, which cites a whole range of cases on this issue, Neves, Santana, Santos, Hood. I don't want to get too caught up in that first moment because there are many subsequent moments, and they get more and more important because as these interviews go on, the defendant's statements get more and more inculpatory.
Was the defendant able to leave after that interview?
At the
First
end
interview?
of that, so this is not, technically, Your Honor, this isn't the first interview. This is the second Westfield interview. There was one on the 1st of November. That's not subject of the motion to suppress. This is the second one. And no, at the end of this interview, the defendant was arrested. Okay. And of course, what's undisputed is that he says, "I want a lawyer, I want a lawyer, I want a lawyer," at the end of the interview.
At that point, they cut the testimony off, though, right?
Pardon me?
At that point, they cut the testimony off. The issue is, the first time he says the statement you just read, they don't cut it off.
Correct.
But when he says, "I want a lawyer," they cut it off.
They cut it off, and then he goes to booking. And in booking, it's undisputed he's asked improper questions, and therefore Edwards versus Arizona is violated. So the next issue is whether the statements he made subsequently.
You're collapsing things. So the first interview, one, he's got his girlfriend's child there, right? So
Correct.
that's, when he says, I don't have no time here, it appears to be referencing the fact that, he's got his girlfriend's child there, and then he keeps talking right after that. It's not as if he's I want to, like he says the next time, I want a lawyer, I want a lawyer, I want to go home, I want to get out of here, I want a lawyer. That's it. They immediately stop that. During the booking process, the defendant spontaneously says, right, without any prompting by police, that the victim had grabbed him. After this statement, while still in Westfield, then they ask the defendant several questions, right?
Yes, Your Honor, I'm following you.
Okay, so I mean, I just want to be as precise as we can
Yes,
about this
yeah.
stuff. Yeah, okay.
And so, and then he's asked questions during the booking process, and the motion judge ordered those questions and the answers suppressed. And that's undisputed. That was a correct ruling on appeal. But now we're under the umbrella of Edwards and Thomas, which, more particularly Thomas, which says that all his subsequent statements he makes after that Edwards violation, the Commonwealth has a presumption of showing that the taint had been overcome.
This is from Westfield to Chicopee now.
Yes, Your Honor.
Okay.
Yes, when he's brought to Chicopee.
Talking about, now, how long had passed?
Yes, let me get it exactly right for you. So
Approximately 2 hours, right?
Yeah.
approximately, but it's noteworthy that in the interim, he's being brought from prison to prison, police station to police station. And so there's two aspects to the whether the taint had been overcome. One is whether the timing issue, which is, this court is pointing to. The other was whether the cat had been out of the bag. And the defendant argues on appeal that that in response to the improper questioning, he made a statement that let the cat out of the bag.
That being?
That being that, let me get it exactly from the
She
brief.
tried to grab me was before the Edwards violation, correct? Or was
Well,
it- Or was it, I'm trying to find out what you say was the result of the Edwards violation, which let the cat out of the bag.
yes. In response to the improper booking questions, the defendant said she tried to grab me. This, of course, put him at the scene of the crime at the time it was committed, and setting aside the possibility of third-party culprit was highly inculpatory.
So your theory is once that improper question happens in Westfield, there can be no questioning regardless, no breaking the action, no re-administration of Miranda, even prompted by your client.
My argument is that
everything
the
was out.
taint wasn't overcome.
Okay.
But Your Honor is kind of leading me to another area, which is...
I don't want to unless you finish.
No,
here.
I'd
Well,
made my argument there.
I'd like to clarify sort of, so some of the stuff he's let out, some of the cat is already out of the bag legally. What difference, how much more of the cat has been let out between the time he says, I want a lawyer, I want a lawyer, I want to stop? So what has he revealed at that point versus the additional information that comes out in the improper booking question about she grabbed me, right? So he's already admitted to being in the apartment.
Right.
Right, so describe what he's admitted to already at that point. Because again, we got to analyze the cat. If you see all the cat but the tail, we still have, it's not that the tail is get the cat out of the bag. You've already let it out, right?
I think Your Honor is looking at the cat out of the bag from a prejudice standpoint, and that's not the inquiry. The inquiry is whether the circumstances were psychologically coercive.
Right.
And so when
It's incrimination, isn't it? I thought it was incrimination. The whole cat out of bag analogy is another word for incrimination.
I don't have the exact terminology before me, but I understand
I mean,
it.
isn't it basically that the person thinks that since he's already
They're
confessed,
defeated.
it doesn't much matter whether he confesses a second time?
Yes, Your Honor. It's psychological coercion. They're giving up.
Well,
Right, but if you've already confessed, and then you add a little more to the confession, that's not what we're talking about here. So you've got to take into account what he's already said and compare it to the additional information he's put in improperly.
Well, the way I handled, the way I wrote it was that,
Get how you wrote it, but
Well,
it's more how people like us write it.
well, I hear you, Your Honor. Yeah, I mean, Your Honor is basically miming what the suppression court said. The suppression court said the cat wasn't out of the bag because he blurted it out before the Edwards violation. But I said, but the contrary is true, because the defendant may have especially felt he had nothing to lose because he had made such a statement and essentially repeated it as a result of improper questioning. In other words, his feeling of hopelessness may have reached a tipping point.
Okay, and now
But-
I'm confused. Did he say that she tried to grab me before the Edwards violation or after the Edwards violation?
He blurted something out akin to the statement he made as a result of the improper booking question before the improper booking
So
question.
she tried to grab me was before the improper booking question.
I don't recall the exact statement. Like I said, it was akin to that. But
But I guess
That-
we're trying to figure out what was said after the Edwards violation.
after the Edwards violation, he said she
Yes,
tried to grab me.
That was said before and after, or something like that.
Something like that was said before.
Okay.
But that's not the strongest ground I have to stand on here before you today. And that is, I'd ask your honors to consider that when he gets to Chicopee, he is Mirandized. He's Mirandized twice, but in the booking area, and then when he goes in for the interview. When he goes in for the interview, he's Mirandized, he's smoking a cigarette. As I alert this court in my brief, he was clearly an addicted smoker.
I was interested in that. Have you found any cases, and maybe I missed them, or either here or nationally, where a nicotine habit has been used as an addictive compulsion?
That's a very good point, Your Honor. It's not something I looked into, frankly.
Well,
But I
usually
meant-
it goes the other way, that they're deprived of a cigarette, not that they're given a cigarette.
Well, I understand where Your Honor's coming from, but consider the context here. If you look at that booking video in Westfield, you see a man who's very agitated. And cigarettes are no small part of that agitation. Of course, he's been arrested and charged with a very serious crime. Also, in the first November 5th interrogation at Westfield, there's a discussion about cigarettes. He wants a cigarette, and the other detective says, we can't do that. So here he is, he's being Mirandized, and he's smoking a cigarette. It's lit as he's being Mirandized. His head is on the table, suggesting he really has kind of lost any interest in the game. So those two things, plus the fact that at the end of the Westfield, I shouldn't say at the end, at a point in the Westfield booking procedure, there was a statement made that he goes, I'm going to die in prison, I'm going to die in prison. And someone chimes in, one of the police officers chimes in, that you will.
Now, that's not clear that he heard that, and it's not clear that was directed at him, and actually, there's a little bit more to that statement, wasn't it? It was a conversation between two police officers as an aside.
And all I can do with that, Your Honor, is to leave it to your de novo review. Look at the video and make your own assessment.
Hey, can I ask you, on the whole theory, because from transport,
Yeah.
because what Judge McDonough looks at is this cat out of the bag notion that we've talked about, but
Right.
what you haven't addressed is the issue of attenuation, where there could be a sufficient break in the action, and it's 2 hours, and our case law varies. What do you say about that?
Well, with regard to the timing issue, I don't think 2 hours is sufficient under the circumstances. And let me put the circumstances right before you.
Before you do the circumstances, can you give me case law on the lower and upper limits of attenuation that we have?
Let's see, I can try. Let's see what I have here. Actually, I don't have case law handy on attenuation, but I do want to point out the factual circumstances here, that it is 2 hours, but you should consider the circumstances that he's being transported from one police station to the other.
Sometimes that goes, again, the other way, in that there's movement, there's a change of scenery that can often, or sometimes, break, cause attenuation.
Well,
I'm sorry, I'm cutting you off as well.
It's okay.
But were they different police officers? Or was it something Justice Cipher picked up on, different environment? Were they different police officers from Westfield to Chicopee, or same police officers?
to my knowledge, the lead interrogator was the same.
All the way through?
Yeah,
Okay,
all the way
thank you.
through. So returning to two things when we go to Chicopee, right? Is whether his waiver of his Miranda rights was voluntary, and whether his statements were voluntary, which are related issues. We have what I think is an impermissible inducement with a cigarette, what the defendant argues an impermissible inducement. The statement, "You'll die in prison," or "that you will," which I understand, Your Honor, is saying there's a quarrel about that, the context of that statement. There's a third thing which I neglected to mention. I did phone up the ADA yesterday, and it's in the record. I would like to point it out. And it's yet another psychologically coercive circumstance, which is at the end of the Westfield interrogation, the second detective, not the lead guy, the second guy, says to my client, he says, DNA, it doesn't just get under your fingernails. It gets under there through a violent confrontation. And I will give you his exact words because I want to be super on the ball about this. But he says, it doesn't just get there. You don't get there from shaking hands. It gets there from violent confrontations. Well, that's not true. And what's more important is, even in the context of this case, and in the facts of this case, that's not true, because we know that under the decedent's fingernails was defendant's, there was at least two male DNAs, right? At least there was my client's DNA and at least one other male DNA under the decedent's fingernails. So what that detective told my client was yet another psychologically coercive aspect of this. It was, it's a misrepresentation, whether intentional or not. Which is, all of this brings us now.
Below?
Pardon me?
Was that raised below?
I don't know if that moment was raised in the suppression papers. It wasn't in my brief. It is on the record on appeal. It is part of the totality of the circumstances, which goes to whether.
How do we know that is inaccurate, by the way? I mean, most of the cases you've got someone's DNA under your fingernails because you're scratching them. So we don't know anything about how the other person's DNA got there, do we?
I don't want to speak outside the record. Mm-hmm. So, but upon information and belief, that is an inaccurate statement.
I know your time is coming.
Yeah.
And could you move to the SOARS challenges about the unsettled feelings? Those seem like an important.
I would like to, Your Honor, but with Your Honor's permission, I'd like to get to the crown jewel of the suppression issue, which is that moment where he says he's done in Chicopee. So after all of this, the Chicopee interrogation goes forward, and he says, let me just get it correctly here. He says, I know I'm going to jail, so I'm not saying no more. So I'm sorry, you have to charge me with this shit, I'm done. You can try this shit, but I'm done. There are literally legions of cases from this court that say that is a clear indication of the right to silence. I'll cite Neves, Santana, Santos, Smith, Commonwealth versus Hood, which is a very recent appeals court case. And, the statement in itself is sufficient, but I would like to point to the context. The context is, he says he's been arrested. The police are obviously trying to build a case against him. The questioning is growing increasingly aggressive. He knew that the police had compelling evidence against him, including his DNA, and Gibbons had just told him that he was going to jail right before he says, I'm done. So that's a clear indication of his right to silence. I'll move forward to the source issue, which Your Honor requested that I get to.
What of consequence was said after that so-called invocation of silence?
Lots. So that is, in my harmless error section of the brief, I say that that's really where you run into serious problems, because after that, I apologize for taking the time. It's just, following that, the defendant, for the first time, one, he sets forth a motive for the crime. Plas owed him $500 to $600 for drugs. He admitted he knew the killer, who was his dealer. He admitted that he came to Plas's apartment with the killer who wanted to get paid, and he said he witnessed the killing. And at the very end of the interrogation, he says he inculpates himself further, suggesting that the repeating of stabbing was motivated by anger because Plas owed him drug money. So this is just incredibly incriminating information.
Two things. What is admitted from that at trial? And secondly, what is new that he hasn't said before, right? Because he's said he's dealing drugs to her previously, correct? And has he said he's witnessed the killing previously too? How much is, again, you're lumping things, but you have to go through hurdles. What's new that wasn't presented, and what actually was admitted at trial?
It's all new, Your Honor, and it was all admitted at trial. It was all admitted because the DVD was...
Because I'm just gonna put a bookmark for Mr. Shepard Brick, because I have doubts about that. But
okay, Your Honor. Turning to the SOARS issue, there was a prima facie case of racial discrimination made out during exercise of peremptory challenges, and this is not disputed. There were three SOARS challenges. I'm only contesting two which were denied on appeal. And in each instance, there was a prima facie case of racial discrimination. And then in the Commonwealth, of course, it was their duty to rebut the prima facie case. They rebutted in each case by saying they had an unsettled feeling, which of course is inadequate. Of course, they did say something more. With regard to the first juror, this is juror 29, I should say the first one. This juror, by the way, this juror appeared to be a person of color and had a Hispanic surname. The prosecutor said she had an unsettled feeling. That feeling arose, she said, from the fact that the juror had an interest in criminal law and was eager to be on the jury despite the fact that she was apparently a single mother of 3 young children.
She originally raises her hand, right, and says, in response to, do any of you have an interest in the case or something like that? I can't remember the standard question, right?
Right. And I saw that in the ADA's papers. I looked back at that, and that is not the Superior Court's understanding of what went down. The Superior Court's understanding of what went down is it's just a moment of confusion. She doesn't have an interest in the case in the way we know it as lawyers and judges.
But that's how she got up in front of the judge, by raising her hand, even though she may have been confused.
I don't recall, Your
And
Honor.
then she talked about her interest in the case.
Right. Her interest in the case was she was interested in criminal law.
Right.
She wants to participate. With regard to the second juror, the circumstances are similar. Again, the defense had made a prima facie case of racial discrimination in jury selection, in peremptory challenges. And the prosecutors says that the prosecutor has an unsettled feeling.
I know this is only one of the factors we consider, but what did the jury, what was the representation on the jury at this point? Was it an all-white or an all-male jury, or what do we have at this stage?
I don't know, Your Honor. I believe that would go to the first step.
Right, the first finding had been satisfied, correct?
The first finding had been satisfied, right. So we're looking just for a race-neutral reason, one that's clear
But
and
an
reasonably
adequate and
specific.
An adequate and genuine explanation.
Adequate and genuine, but clear and reasonably specific too, Your Honor. And my argument on appeal is that the reasons set forth by the prosecutor weren't adequate, weren't genuine, and weren't clear and reasonably specific.
And what were the reasons for the second one?
The second challenge,
Second one is the second one, right, is about whether the reasonable doubt, how she interpreted how to interpret reasonable doubt, and whether she would have remaining questions even if there was reasonable doubt, right?
well, the record's a little thin on this one. So what the prosecutor says, I didn't like her answers to the Commonwealth's questions. She's very young, and she indicated when she was questioned that she would have questions that could cause her to change her mind if they weren't answered, even if the Commonwealth proved beyond a reasonable
But
doubt.
that's the CSI type question, right? It's the absence of evidence question, sometimes asked by prosecutors.
I don't recall exactly
Yeah,
how
but
this.
it goes to like,
Yeah. But when the court denies a challenge, I must say that what the court puts on the record there is awfully thin for the purposes of reviewing the denial of a source challenge. And of course, there's case law on that there should be adequate record keeping in the Superior Court when there is a source challenge. If the court has no further questions, I'd rest on the brief.
Okay, thank you.
Thank you.
Mr. Shepherd-Brick, good afternoon. No, still good morning.
Barely.
Good morning for another 9 minutes. May it please the court, David Shepherd-Brick on behalf of the Commonwealth. I'll start in reverse order where the defendant left off with that final juror. That final juror said that she, I think it was juror number 2 that day, that final juror said that she would not be able to set aside her unanswered questions, even if the case was proven to her beyond a reasonable doubt. The judge made a finding that she could follow his instructions. I'm not entirely sure that finding was supported by her answers to the questions. There was a challenge for cause.
I think the first juror is more troubling.
Yeah, I would agree that there's a little bit more there.
As your client, as counsel eloquently put it, the Leave It to Beaver lifestyle.
Right. So it's interesting because when they're talking, I believe it's about when they're talking about that
Because
juror.
unsettled feeling is really
Well, she does.
really troubling because
Right. She does say unsettled feeling, which was an unfortunate phrase that she seemed to repeat a number of times when she's talking about these challenges for cause.
it's really no explanation.
Right, and if she had just said unsettled feeling, I think there would be a serious issue. But what she said was, I have an unsettled feeling because that juror, the question was, do you have an interest in this case or its outcome? And there were several other jurors that day who raised their hand. Juror number 97, juror number 39, juror 37, 11, 51, and 23, in addition to 29. All of them understood the question. All of them were, 11 was excused for a hardship, but knew the victim.
It's a strange question because as lawyers, you certainly understand it, but to a layperson, it might be different because if one asks you, do you have an interest in this case? You, of course, would say, I don't have an interest in this case. I have no financial interest. I have no personal interest. But if someone says, are you interested in this case? It could be, would you find it interesting? Is this something you'd like to participate in? That could be an interest. So it's kind of a tough question that we take for granted because of the legal context. But to a layperson, it maybe is more tricky than we give it credit for.
No, and I understand that too. But then she doesn't bring it up at sidebar, even though the judge says, did you raise your hand to any questions? She didn't bring that up. And then when she's brought back up, on the record, she says, no, she's just interested in criminal justice. The judge found that credible. The prosecutor did not. And I think that's what it comes down to is the prosecutor's unsettled feeling was that she didn't believe the juror when she said that was her only, because she'd raised her hand, because she didn't bring it up. And I think that the judge found her reason to be both adequate and genuine. And I think that's really important, that the judge said, yeah, no, I believe you.
I get the genuine part. How is it adequate?
Again, I think it's adequate because, well, you know, we might look at it here and say, well, maybe the juror just didn't understand the question. We weren't there. We weren't able to observe the mannerisms, and the trial judge, you know, found that the prosecutor's reasons were adequate and genuine, particularly given the prosecutor's feeling about the juror based on her. And again, it's specific to the juror. She said she had an interest in the outcome of the case. Whether or not she misunderstood the question is left up either to the prosecutor to decide whether or not she believes her, and the judge to decide whether or not she believes her. But if someone has an interest in the outcome of a case, they're not impartial.
Was that the question, interest in the outcome of the case or interest in the case?
Interest, the question was interest in this case or its outcome. So I think that you raise your hand to that question, you're saying,
Well, it's confusing. It gets more confusing.
no, and it certainly could have been phrased better, but I think that's where the trial judge really comes in here, and you know, he asks the questions of the juror. He gets an answer that satisfies him, and it doesn't satisfy the prosecutor. But the fact that the judge agreed to engage in questioning the juror about it means that there was at least a concern raised about that juror's answer.
If I can turn you to the so-called invocation of silence during the Chicopee interrogation.
Right.
We just had a prosecutor, I think you may not have been here, in the Lopez case, who said, where the defendant said, "I'm done talking," said, well, they conceded that was an invocation of silence. Here, he says, I know I'm going to jail, so I'm not saying no more, so I'm sorry, you have to charge me with this shit, and I'm done. You can try this shit, but I'm done.
As it turns out, he actually, in the transcript is wrong there. He does not repeat the phrase, you can try this, but I'm done.
Okay, but he still says it one time.
He does say it
I'm
once.
sorry, you charged me with this shit, I'm done. Why is that not a clear enough invocation to trigger either the end of questioning or at a minimum the request for clarification of whether he wishes to end questioning, especially where he had, this particular interrogator had heard him do it, was aware that he had invoked, he'd asked for an attorney earlier.
Well, right, and I think that he knows how to invoke both his right to an attorney and his right to remain silent. And this court has said many times that it's, you know, the context both before and after that are relevant to determining whether or not it's a clear invocation of silence. And what I would say is, you know, the defendant says, I do, but I can't really say anything. And Sergeant Gibbons responds, why can't you? And the defendant says, because if I go to jail, I'm getting killed. I can't say nothing. I really can't. I hold to my word. I can't say nothing. And then that's when Trooper Gibbons responds, hold to your word. Hold your word to who? You're going to jail, though. And that's when he says, I know I'm going to jail, so I'm not saying no more. And I think that relates back to his statement that I can't say anything because of the supposed threat that this individual made to him. And if you look, that's the transcript is provided in the Commonwealth's second appendix. If you go later on in the interview, it's reflected on page 225 of the Commonwealth's appendix, but he repeats the phrase, but this time he says, I'm not giving you his name, I'm sorry, but you guys want his name and I'm not giving you his name. You guys can charge me with this. I've already been charged with this, so I'm not giving you his name. And so I think it's clear you look forward and you say, when he's saying that, and I think the motion judge properly considered that in the totality of the circumstances. I'd also point out that I disagree with defense counsel. This is not de novo review. As this court said in Clark, when there is testimony and video, and there was testimony about these invocations, and Trooper Gibbons testified, I didn't take it as he was trying to cut off questioning. And he's in the room, and yes, there's a video and audio recording. It's certainly not the best video. The audio is pretty good. But if that's how he understands it in the context, and the motion judge clearly credits his testimony, I think that we're more under the clearly erroneous
I
standard.
mean, it's not what he thought, it's what a reasonable person would have thought. So it's a reasonable person standard, not...
Right, but I think what he in the room thought, certainly a factor to be considered in what a reasonable officer would consider.
Do we consider what's said after? I mean, I know that the judge said it was at this point that the defendant made the statement, I'm sorry, after this exchange, Trooper Gibbons said, we won't throw the guy's name in here. Mm-hmm. And then he freely and willingly resumed talking about what happened. But don't we have to examine it at the moment that it is said? I don't think an officer can continue the questioning and then say, well, after I continued to ask questions, it turned out that looking back, it was not an invocation of silence. That would encourage, we want officers to, when they hear an invocation of silence, to either stop or to say, let me be clear here, are you asking me to, are you invoking your silence or not?
Well, so what I would say is first, this court does look to before and after, both in Commonwealth versus Almonte, cited in the Commonwealth's brief, quoting or citing to Commonwealth versus Senior. The court said the circumstances immediately before and after the defendant's isolated remark support our conclusion that the defendant did not invoke his right to remain silent.
I've got to go back to those cases. Was that because the person was answering further questions or because the person continued to speak?
That's because they responded to further questions.
Okay, is that right? I mean, it seems to me that the time to look at this is the time at which the statement is made. That's if we expect a reasonable officer to stop questioning at that point in time, the reasonable officer is not going to know what's going to happen afterwards.
Well, right, and if he had said, I'm invoking my right to remain silent, then obviously you don't have continued questioning. But where the difficulty with the right to remain silent is sometimes I think I've said all I've had to say is an invocation, and sometimes it's not. Particularly
Well, he said two things, so I'm not saying no more and I'm done.
Right, that's what he said, and I think the motion judge properly found that in context, he was not cutting, he was saying, I'm done talking about the guy, I'm not telling you who he is.
But if you look at what the judge found, he was relying upon what happened after Trooper Gibbons. He writes, Trooper Gibbons said, we won't throw the guy's name in here. As soon as Trooper Gibbons told the defendant they would not use the man's name, the defendant freely and willingly resumed talking about what happened. Thus, I find that the defendant simply did not want to reveal the identity of the person that he claimed killed the victim. Isn't that relying upon what happened after in response to what the officer said, which is not what the officer is supposed to do if he's supposed to respect the invocation? Well,
Again, he didn't understand it as an invocation, so looking after that to say, what was happening in that room, what was the officer's understanding of what's going on. Obviously, if it is and I don't agree that this is not a clear and unambiguous invocation of his right to remain silent. Again, if he had said, like he did before, I want a lawyer, I'm done, I want to go home, that's an invocation of both his right to counsel and an unambiguous invocation of his right to remain silent. You can try this, but I'm done, in context is not a clear invocation. So the fact that it continues.
Let's be fair. He said, I'm not saying no more, and then he said, I'm done. So there were two statements that arguably were invocations of silence. So I know I'm going to jail, so I'm not saying no more. So I'm sorry you have to charge me with this shit, I'm done.
I agree that those are his two statements. I think they were made in response to the trooper's questions. And the trooper's questions is in response to him saying, I can't give you his name. And the trooper says, why can't you give us, something to the effect of, why can't you give us his name? You're the one who's going to go to jail. And that's when he responds with that. So in context, what he says, then the police officer's response to it, and then when he says that, in that context, it's reasonable that the officer understood it as, look, I'm just not, you can try whatever you want, I'm not giving you his name.
We'll obviously look at it. Assume for the moment that you're wrong. I'm not saying you are, I don't know. Is it harmless beyond a reasonable doubt?
After that point in the interview, there's nothing really significantly inculpatory after that statement. He certainly, has some new version. He brings in.
Has he already admitted at this point that he's in the apartment? I'm trying to understand.
Yes. By that point in the Chicopee interview, he has put himself. I mean, this is after the booking. This is after he's put himself, struggling with the victim, struggling with the purported assailant. It's what I will say is it's difficult.
I'm repeating what Mr. Fishman said, without being exact. For the first time, he's saying he got $600 in drugs. He witnessed the killing.
He had said that he hadn't said it was drug related, but he said he was present for the murder. What I will say is.
So he had previously stated that he was present for the murder before this point.
Yes. Actually, at the end of right before the booking, before the Edwards violation, he says, that she grabbed me and I tried to save her.
So the grabbing and trying to save had already come in.
That had already come in. And the outset of the Chicopee interview is, I'm going to tell you about the guy. So at that point, what I would say is that there is one thing that does come after the supposed invocation, and it is his statement, wow, I was just thinking to myself, how do I get myself out of this? So
just the statement that was used, the first statement made in the opening statement.
Right.
So that's a problem.
I'm not giving up the harmless beyond a reasonable doubt argument,
but you do have to deal with that issue.
I do have to deal with that.
Was there any? Your brother, and I think in the brief, says that it was after that he said that the class owed him $500, $600. Was that the first time that had come out that she owed him money?
Yeah, the money motive, that was, I believe that is correct, that the first, because that comes after, they have this exchange where, I'm not going to give you his name, you can try it, but I'm done. And then he says, we'll leave his name out of it. And then he says, the defendant's like, oh, well, then I'll keep talking to you. And then that's when Sergeant Gibbons floats the idea. He's like, well, maybe she owed you money. So that's when that does come after that. But he's already put himself in the room. He's already put himself struggling with the victim. I don't know that particularly adds anything. He's already told 3 or 4 different versions by that point. I'm not sure if there's any other issues the court wants me to address. I would, in terms of the Edwards violation, he had already admitted to being there. He'd already admitted to being grabbed. What he repeated in the booking procedure, it had already come out spontaneously.
Can you address the attenuation argument?
Right, so it was 2 hours later. It was in a different police department. He was booked in Westfield. He was transported to Chicopee. He was booked in Chicopee. They did repeat his Miranda rights at the Chicopee booking, but they said, I'm going to be asking you booking questions. He's then taken to a cell. Sergeant Gibbons doesn't remember if he actually got to the cell, or if, but he was going to transport him to the room to be fingerprinted, the major case prints, and that's when he says, I want to talk. So it's reinitiated by the defendant to the extent that he's already incriminated himself. That happened before the Edwards violation, so the cat was already out of the bag. So this is the defendant's attempt, his third attempt to try and spin the facts towards him not being the murderer.
No, he's being booked for murder.
Yes.
Okay.
So he was
He's already been charged with this crime.
Yeah, no, I mean, he knows that, so that's certainly a factor. But what I would suggest is one of the strongest factors is you'll have the videos to look at. There are no improper tactics in any of these interviews. I would say, against having to step outside the record, his statement about it only gets there through violent confrontation is entirely accurate.
I'm sorry, he only gets there through violent conflict?
DNA.
Oh, the DNA, I'm
The
sorry.
the DNA that was the trooper's statement, that only gets there through violent confrontation. That wasn't raised below. We would have put on someone from the DNA lab to say that's absolutely 100% correct, that's how that gets there. I see my time is up. If there are no further questions, I will rest on my brief. Thank you.
All rise. Hear ye,